We have filed a class action lawsuit against Logan Paul, CryptoZoo Incorporated, and the rest of the CryptoZoo co-founders. In today's video, I'm going to be discussing how we could do this from a legal point of view, why this is different than the arbitrations that we've already filed, and who would be in the proposed class if we are successful in getting it certified. A couple weeks ago, I made a video announcing that we had filed our first arbitration case against the CryptoZoo gang. Since then, we have actually filed more arbitration cases. And in that particular video, when I was announcing the filing of the first case, I went over a version of CryptoZoo's terms and conditions, which included a class action waiver and an arbitration clause. And I explained that for that particular individual claim, we felt like those terms and conditions were applicable, hence why we filed an arbitration. At this point in time, you're probably asking yourself, hey Tom, how can CryptoZoo's class action waiver and arbitration clause apply to one person but not another person? I'm confused. And that's a great question, and I did a little bit of foreshadowing of this in my previous video. Okay, so to recap, there is a forced arbitration provision and a class action waiver in their terms of service. I do not want to suggest to you that just because a company puts something in their terms and conditions, that term or condition is automatically enforceable. In fact, I think there are quite a few terms and conditions present in the CryptoZoo agreement that I believe are unenforceable. And on top of that, I think that these terms and conditions as a whole might be unenforceable for a certain class of people. So we certainly have been thinking about this issue for a very long time. And to best explain what exactly is going on, I think it's best to establish a timeline. CryptoZoo officially launched to the masses at the end of August, beginning of September 2021. At the time of the launch, the CryptoZoo's terms and conditions actually did not include a class action waiver, nor did they include an arbitration clause. Behind me are the original version 1 of the CryptoZoo terms and conditions. As you can see, it's not very much. This is actually the entire thing. And it says nothing here about a class action waiver nor an arbitration clause. It does say something very important at the very bottom. These terms are subject to change. We may revise these terms from time to time, and the most current version will always be on cryptozoo.co/terms. You are responsible for reviewing and becoming familiar with such modifications. Revisions deemed material in the sole discretion of CryptoZoo will include a notification via Twitter or Discord. By continuing to access the CryptoZoo website and by holding the CryptoZoo NFT, you agree to be bound by the current terms. Okay, so let's continue with our CryptoZoo timeline. CryptoZoo is now public. There's a lot of hype around it. At the same time, when the game first initially was launched to the masses, we believe a lot of the CryptoZoo co-founders conspired and actually sold a lot of their Zoo token, pocketing millions of dollars at consumers' expense. Meanwhile, at the same time of this dump, the game clearly doesn't work. All of the hype kind of fizzles out because nothing promised was delivered, and simultaneously, the price just goes down and down and down. Which brings us to January 20th, 2022, which is the day that we believe CryptoZoo updated their terms and conditions to version 2. Now, version 2 is the terms and conditions that includes the class action waiver and arbitration clause. By updating to version 2 of the terms and conditions, the CryptoZoo team did something called a unilateral modification of terms and conditions. So now the key question is a unilateral modification of terms and conditions valid? And in order to decide this, we first need to determine what type of online agreement were these terms and conditions. Now, generally, there are 3 main types of online agreements that consumers are faced with on a day-to-day basis. The first is something called a click-wrap agreement. A click-wrap agreement requires a user to agree to the terms of a contract by selecting I accept or I agree button on the website after being presented with the terms or a link therein. The second type of agreement is called a browser wrap agreement. A browser wrap agreement does not require an express manifestation of acceptance. Rather, a user gives their assent simply by using the website. The defining feature of a browser wrap agreement is that the user can continue to use the website or its services without visiting the page containing the terms of use or even knowing that such a page exists. And the third is called a sign-in agreement. A sign-in agreement notifies the user of the existence of the website's terms and conditions and advises that the user that they are agreeing to the terms when registering an account or signing up. The user is presented with a hyperlink to the terms and must affirmatively click to accept the terms. And after examining the CryptoZoo terms and conditions, this is clearly a browser wrap agreement. None of the CryptoZoo consumers had to go to the CryptoZoo terms and conditions page. In fact, a lot of them didn't even know it existed. So now we have to ask ourselves, does a unilateral modification of a browser wrap agreement retroactively affect a consumer's rights to bring legal action? And the answer to that is yes and no. Simply put, this is going to depend on what jurisdiction the consumer is in. Some jurisdictions have broader consumer rights protections, one of which is the state of Texas, where I'm from and licensed. Okay, so behind me is an article from another lawyer's website. I promise I did not write this. I did not make this up. This just shows you that this is a fairly well-established principle in Texas. Unlike California and Illinois, Texas law does not allow parties to retain an unrestrained right to unilaterally modify arbitration agreements retroactively and without notice. Any attempt to do so renders the arbitration agreement illusory and therefore unenforceable. Under Texas law, contracts must be supported by consideration. In the arbitration agreement context, that consideration is typically a mutual agreement to arbitrate. However, if one party can avoid its promise to arbitrate by amending the agreement retroactively, there's no consideration and therefore an enforceable agreement was never formed. Put differently, a promise is illusory if it does not effectively bind the promisor. So to apply it to the situation here, essentially what we believe this says is a court will not allow a party to cause damage, all of this harm with version 1 of the terms and service, and then suddenly just apply version 2 of the terms and service retroactively to the users who were already in the ecosystem and already damaged by what was going on. So to put our position more concisely, in the state of Texas, we believe that just because the version 1 of CryptoZoo's terms and conditions says we may revise the terms from time to time, doesn't mean that everything they put in future terms and conditions is automatically enforceable. When you add an arbitration clause, when you add a class action waiver, there was no assent, there was no meeting of the minds by the CryptoZoo consumers because this was a browser wrap agreement. Therefore, there was no consideration making this updated terms and service version 2 illusory. And the whole reason why I'm making this video is because I don't want CryptoZoo victims to get confused. While we are doing these arbitrations individually in Delaware, this class action in Texas will be going on simultaneously, but they are different and the class action certainly does not apply to everyone. And the reason why I do this is because the media is just getting this wrong. Behind me is a CoinDesk article, and I don't mean to pick on CoinDesk. They're just one of the many news outlets that is not understanding what is happening. Look at the last line of this article. The proposed class action includes any of the 2,000 token holders of CryptoZoo NFTs. That is not correct. This is going to vary from jurisdiction to jurisdiction. The class that we are seeking to get certified just has to do with Texans. Nobody else at the moment. Just people in the great state of Texas. If you are not from Texas, you might be in a jurisdiction that enforces the unilateral modification of terms and conditions retroactively, meaning you will have to go to arbitration if that's the case. So if you are a CryptoZoo victim, please, just because you hear the words class action lawsuit filed does not mean automatically that you're going to be included in that class. Please, go talk to a lawyer. It does not need to be me or my team. Go talk to a lawyer that you trust if you've been harmed in this, because you very well may have to go and file an individual arbitration if you want to have a fair shot to get compensated. All right, that's it for today's video. Bye. Attorney Talk.